All right, cool. So, nice to meet you. My name is Matt Margolis, and my partner Lauren Weldon and I have a small estate planning elder law practice, Margolis Weldon. We're in Park Ridge. We help people with wills, trusts, powers of attorney, and we work with folks of all ages. We do work for 18-year-olds going off to college, getting powers of attorney in place, all the way to working with folks in their 90s and 100s who may need elder law assistance with regard to Medicaid or asset protection. And sometimes it's just getting the right documents in place with wills and trusts, etc. So actually the information that I'm going to discuss with everybody today is really exactly what I discuss in an initial meeting when clients come in. Most people really don't know the ins and outs of wills and trusts, powers of attorney, etc. I mean, they've maybe done some research online, and we all know how dangerous that can be. And so really the goal is to educate you and make sure that you understand what all these options are and what options you have when it comes to doing some planning. And that way, whether you have some planning in place or whether you're looking to do some planning at some point in the future, hopefully you go into it with a little bit more eyes wide open than you came in. So when we look at planning, there's really two main options that we discuss or that we think about. We look at wills and we look at trusts. And I would say that the idea of a will is way more comfortable for people, or much more comfortable, because it's one of those documents that our grandma mentioned at some point, like, oh, I've got a will in place, or maybe your parents said they have a will. And the reality is some people that even have trusts in place refer to it as a will because the idea of a will is just so commonplace. Then we flip to the idea of a trust. And I think when there's a big misnomer out there, because I think when a lot of people hear the term trust, they go to this place of, trusts are just for rich people or wealthy people, whatever that means. And obviously all of our definitions of rich or wealthy or anything of that sort is different. And I think a lot of that is due to the media, right? We see movies and TV shows, and there are people that talk about trusts or trust funds, and it's always associated with somebody that has a lot of money. Similarly, maybe you went to college with a trust fund kid or a trust fund baby. And so again, we sort of associate this idea of a trust with wealth. And I think that, in going through all of this with you, you'll really understand that that's not really what a trust is. And it can mean that for certain people, don't get me wrong. But I can tell you that the average person that at least we work with in our practice, they're putting a trust together, and it's not because they're wealthy or because they're rich, again, depending on your definition of that. It's really because they're just looking to put a plan in place that it will make things easier on whoever they're leaving behind. So let's sort of talk about the idea of a will, or really just the idea of how an estate sort of can work for somebody that maybe does no planning, right? And so we'll use me as an example, right? And so at some point I'm going to die. And I'm sorry to burst your bubble. You will too. If it's the first time you're hearing that, I'm sorry. But we all have an expiration date. And so when I pass away, ultimately there's this process in Illinois where a judge is in charge, and the judge is looking to determine how my estate should be distributed. And that process is called probate. Maybe you've heard of it before, maybe you haven't. Maybe you've dealt with it before. And if you have, hopefully it wasn't terrible. In some cases it's pretty smooth, in some cases it's not. And so the idea of probate, or the idea of an estate going through the court system, is going to be dependent on a few factors. So if let me step back. The reason why my estate would go through probate is if I own assets in my name only at the time that I die, and they're not in a trust, they're not owned jointly with somebody else, and they don't have beneficiaries. Okay? So a lot of married couples can sort of get away with doing no planning at all and still avoiding probate. And that's because a lot, and obviously not every single one, but a lot of married couples tend to own things jointly, right? So my wife and I, before we did any planning, all the bank accounts and brokerage accounts were joint. The condo we owned was joint. Now when it came to any IRAs or 401ks we had, or life insurance, while those weren't joint, we were beneficiaries for one another. So the reality is, even with doing no planning, if I had passed away, everything would have gone to my wife, right? Either because she was already a joint owner, or by virtue of being a beneficiary. Now the reality is I could have, John Doe over here as the beneficiary of my will. Okay, so let's use that same example. John Doe is the beneficiary of my will. Everything goes to him. In this example I just gave you, if my wife is joint owner of all my assets, or if we're joint owners of all the assets we have, and she's the beneficiary of all those assets that we're not joint owners on, everything goes to my wife and nothing goes to John Doe by virtue of the will. Because beneficiary designations and joint ownership supersedes language in a will. I tell clients that really a will is like a letter to the judge. Dear Judge, my name's Matt Margolis, and if you're reading this, two things happened. One, I passed away. Two, there were assets that were in my name only at the time I died that did not have any beneficiaries. Okay? If that scenario doesn't happen, if I have joint ownership, if there's all the assets I own have joint ownership, or there's beneficiaries, nothing will go through probate. The language in my will never come into play. Okay? Now, of course, if something does slip through the cracks and there is no beneficiary on something I have, then it will go through probate. Then my will kick in. And I will tell you that for most people, I shouldn't say for most, but for a lot of people where we see probate kick in a lot of cases, some people think they've had it all figured out. They put beneficiaries in all their assets. They maybe had their kids as joint owners. I don't necessarily think these are the best planning tools, but people do them. The one thing that sort of tends to slip through the cracks is the house, right? So real estate they own, because they don't tend to add their children as joint owners on their real estate. And I'll tell you that it's really not a good idea for capital gains purposes and gifting reasons, and we're not going to get into any of that right now, but just saying that that's not a great idea, even though it avoids probate. And so the house can be that one thing that sort of slips through the cracks and goes through probate. When we look at probate and when we look at how a will works, really within a will, we're talking about who's getting our stuff, right? That's what we tend to think of first and foremost when we're putting a will together. I'd say a lot of young couples, their first thought in putting a will together might be who's going to take care of our minor children, right? And so in a will, we're doing a few things. We're naming somebody that is going to manage our estate, right? Who's going to manage everything that we have when we die and take care of this probate process? And that's called our executor. Okay, so we name an executor, and really the executor is going to hire a lawyer, and the executor is going to work closely with that lawyer, and the lawyer is going to file all the paperwork and all the forms and deal with everything that has to be done in court. And then the lawyer really is going to guide that executor and tell him or her what he or she has to do to make the probate process work smoothly. Okay. So we have executors first. We can name multiple executors. We can name 5 different executors one at a time. We can name 2 executors as co-executors to work together. If we do that, we obviously want to make sure that it's 2 people that know each other and that get along. Naming 2 people as executors that maybe don't have a relationship, or maybe that don't have the best relationship, probably not a great idea to name them together. Thinking that, when we die, they're all of a sudden going to come together and work really well. Probably not. Unfortunately, at death and divorce, we tend to see the worst sides of people. And so, we want to be conscious of those things when we're putting our planning in place. And so we're naming executors first and foremost as who's going to manage the estate. Okay, the executor is not necessarily who's going to inherit from us. It's just who's going to take care of everything from an administrative standpoint. Then we have beneficiaries. Beneficiaries are the people that are going to get everything from us, right? And that might be our kids, that might be our grandkids, that might be nieces and nephews, brothers and sisters, charities. Obviously, everybody's got their own idea of who they want to leave their estate to, and those are the beneficiaries, okay? And we can leave it to as many beneficiaries as we want. We tend to look, when we leave money to beneficiaries, we tend to do that in terms of percentages. Sometimes we'll have clients come in and say, well, I want to leave 50,000 of this person and 10,000 of this person, and that might work depending on the size of the estate that somebody has. But what we have to be conscious of is when we make those specific bequests of 10,000 or 5,000 or 1,000, those will all come off the top. And then if we say, okay, then the rest goes to my 5 kids equally, well, if I've got $500,000 and I leave specific bequests to a few different charities and a few different nieces and nephews that total $200,000, at this point in time, my kids are going to split $300,000. But what if over the next 25 years of my life before I pass away, at the time I die, I'm now down to $220,000? Those charities and nieces and nephews will get that $200,000, and then my kids will split the remaining $20,000. All right, so we tend to think in percentages. just because our estate's going to change over time, and we know in a lot of cases post-retirement, we're probably going to start spending more money, and our estate will probably go down, depending, okay? And then if we have minor children, then in the will we're naming guardians, right? Who's going to take care of our minor kids? If my wife and I don't survive our youngest child turning 18, who do we trust to take care of them? This might be a brother or sister of ours. It might be our parents. It might be good friends. It might be cousins. I think a lot of people kind of get caught up in, that it has to be a family member. It has to be, a parent, or, I think with a lot of estate planning, people get worried that if they don't name somebody, that person's going to get offended. In reality, I always tell clients, this is where you really have to be selfish in your planning. I'm not doing myself, my estate, my kids any justice if I'm simply naming people so I don't hurt their feelings. I want to make sure that I'm naming the right person for the job, and in some cases that might not be naming our parents as guardians for our kids, maybe because our parents live out of town, maybe because our parents are older, and our kids would be better suited, if something happened to us, living with a younger couple, still having a grandparent relationship, just not having the grandparent be their primary caregivers. So again, things to consider. Probate on average, and we practice in Cook County, but our firm's in Cook County. Most of the work we do is in Cook County, Lake County. I would say the average probate estate that we see, that we work on, for a simple probate, meaning, I don't care if you've got a $2 million estate, a $500,000 estate, a $3 million estate. Simple meaning people aren't fighting, people aren't arguing, right? There's simple and straightforward probate estates, just like there's simple and straightforward divorces. There's also very messy probate estates, like there's very messy divorces, okay? And so I would say for a more simple probate, probably $5,000, $6,000 on the low end, $10,000, $12,000 on the higher end. Doesn't mean it can't be a little less than 5 or 6. Doesn't mean it can't be more than 10 or 12. Just, I would say that's sort of the average that we see. And from a timing standpoint, probably 16 to 24 months in court. Doesn't mean you're in court a lot. It just means from 16 to 24 months from the time that estate gets open in court to the time that you are totally done is probably the expected length of a probate estate. Is any of that the worst thing in the world? No. Do most people that I meet with think that's ideal? No. So how do we avoid probate? Well, that's really where a trust comes in, all right? The type of trust we'll talk about today, which is really the most common type of trust out there, is what we call a revocable living trust. There's different types of trust. There's supplemental needs trusts. There's irrevocable trusts for asset protection. There's various trusts for folks that have larger estates where we're looking to really protect against estate taxes. That's not what we're typically using a revocable living trust. Those are just different situations. We're not going to get into that. Really what we'll talk about is the revocable living trust, okay? This is the most common type of trust. I would argue that if you talk to any family members or friends or relatives of any sort that have a trust in place, I'd probably say 99% chance they have a revocable living trust. So again, we'll use my wife and I as an example, right? So we create a revocable living trust, all right? And we have a joint trust for the two of us. We are what's called the trust makers, right? Very original term. We are the ones making the trust. We are going to decide what the terms of the trust are, right? Who gets what when we pass away? How do they get it? What happens if one of them passes away before us? Where does their share go? Who's going to be in charge? So we get to decide all the terms of the trust. The fact that it's revocable, this means that as the trust makers, we can make changes to it over time, as long as we have capacity. We lose capacity, right? A doctor puts something in writing saying that we no longer have the ability to make our own financial decisions. No more changes to the trust, right? So we are not only the trust makers as the ones creating it, but we are also going to be the trustees, okay? The trustees of the trust are the ones that have access to what's in the trust. And I'll talk about that in a second, as far as what I mean by what's in the trust, okay? But as the trustees, sort of look at a trustee as almost like an executor, right? We're managing the assets in the trust. The difference is that a will doesn't kick in until we die, right? That will is meaningless during our lifetime. Remember the phrase, letter to the judge, right? If the judge isn't reading it, that will doesn't do anything, okay? With a trust, it's a living, breathing document from day one. The goal for most people that put a trust together is to avoid probate. Now, I mentioned a second ago, the trustees are the ones that have access to what's in the trust. Well, the way that we avoid probate with a trust is not just creating a trust, right? It's not just good enough to go to an attorney, put a trust together, walk out and say, all right, we're good, we did it. We actually have to retitle our assets to the trust. If we do not retitle assets to the trust, we can still go through probate having a trust in place. And I'll talk about that a little bit as well. And there's a lot of people that don't know that. There's a lot of people that unfortunately might have worked with an attorney who really didn't tell them that. And so you've got a lot of people that have trusts in place that still go through probate, and that should not happen, okay? So my wife and I, as the trust makers, create this trust. And we, in order to avoid probate, we are now retitling our assets to the trust, right? So we're going to go to Bank of America and retitle our checking and savings accounts to the trust. We're going to go to our financial advisor at Merrill Lynch or UBS or Wells Fargo and retitle those investment accounts to the trust. The attorney that we're working with will put a deed together and transfer ownership of our house in Cook County from the two of us jointly to our trust. And if we have any property in another state, maybe we're fortunate enough to have a lake house in Wisconsin or Michigan, well then we'll work with an attorney in that state to put a deed together to transfer title of that property to the trust, okay? So now we've got all of our assets in the trust. And now there's certain assets that are not going to go in the trust. Life insurance policies, IRAs, 401ks. But we're going to make sure that we've got the right beneficiaries named on those, okay? So again, as long as we have our assets either in the trust or there's beneficiaries on them, we have a situation where now we're using the trust to our benefit and we're avoiding probate. So my wife and I are trustees. Great, so now we have all of our assets in the trust. The trust operates off our Social Security number, okay? So I always tell clients that when we create a trust, really nothing in our life changes. We're filing the same tax return that we filed every year. We still have access to all of our accounts. We're still able to pay our bills and work with our financial advisor and go to the bank. Literally the only change you will see is when you get that statement from Bank of America, rather than saying Matt Margolis and Christina Margolis and then our address, it's going to say the Margolis Trust. Matt Margolis trustee, Christina Margolis trustee, and then our address. That's really the only difference you're going to notice once a trust is put in place. Again, no changes from a tax standpoint. Doesn't affect your life in any meaningful way. Again, we're really just using this to create a more simple and straightforward process after we pass away, avoiding probate, making things easier on the family, really creating a situation where it's really a private process, okay? So I mentioned the fact that my wife and I would be trustees, right? So we're co-trustees. Well, if something happens to me, then my wife is the sole trustee, okay? Whether I'm incapacitated or deceased. Vice versa, something happens to my wife, I'm the sole trustee. What if something happens to both of us? Well, we name successor trustees in the trust. Again, sort of very similar to the idea of naming executors of the will. Again, the difference being though, if I pass away and my wife is incapacitated, that successor trustee is going to step in during her life and will step in and manage all the assets in the trust, whether it's bank accounts, real estate, etc., for her benefit for the rest of her life, right? And then upon her passing, that trustee will stay in place and wrap up the estate, right? Sell any real estate, pay any final bills and expenses, and file a final tax return, and at the end of the day, distribute the assets to the beneficiaries in whatever manner that we laid out in the document, okay? Similar to the will, we can name as many trustees as we want. We can name co-trustees, right? So we can name two people together. I don't love naming more than two people together. I've got some clients over the years that have named three people, right? They're adamant about all three of their kids working together as co-trustees. That's fine. I will always sort of give them my disclaimer that I think three people sort of like too many cooks in the kitchen, you know. But of course, if it's three people that you know for sure will get along, great, fine. At the end of the day, it's not my document, right? It's something that you have to live with. So we name successor trustees in the document. And then we talk about beneficiaries, right? Who's going to get everything when we both pass away? Well, I'll give you our example, right? We've got two kids. Everything goes to our two kids in equal shares. I'd say most clients we have that we work with that have children tend to leave things to their kids, but of course, some people might leave a portion to charity. Maybe they've got a godchild that they're very close with, and of course, we can leave money to whoever we want to. And so we have everything going to our two kids equally. Great. When we leave money to beneficiaries, we can leave it to them in one of two ways. We can leave it to them outright, meaning let's say there's $1 million at the end of the day. After all taxes, fees, expenses, whatever, there's $1 million. The trustee that's stepped in now for our trust, let's say it's my brother, Uncle Mike, the trustee, is going to write each kid a check for $500,000, and that's it. Everything's done. Now, what most people do that have younger children, and not necessarily minor children, but younger children, is they might put some language in there to say, you know what, my kids are definitely young at an age right now where if something, God forbid, happened to us anytime in the very near future, we would not want our kids getting this money directly, okay? And so this is sort of back to that term, trust fund kid, right? And so what we have and what a lot of couples do, a lot of people do that we work with that have younger children is we have a provision that says everything's going to go to our two kids, but if they are under the age of, and what we have in our document says they're under the age of 30, then there's going to be two separate trusts that are going to be created, right? Our trust is going to spring into two trusts, one for our son, one for our daughter. And Uncle Mike, the trustee, is going to manage those trusts for their benefit until they turn 30. Now that's just the age we picked. Of course, everybody can choose their own age, right? We all get to determine at what point do we think that our kids will be responsible enough to manage the money. Now, in some cases, we work with clients that have kids that are already in their 20s, but they're just not really showing themselves to be very responsible. And so those clients might set the trust up that way and say, you know what, we don't want our kids to have it till they're 35 or till they're 40, right? Everybody's got their own version of this. So ours says our kids don't get it till they're 30. Well, what would happen if they're under 30 is the money gets divided, these two trusts are set up, Uncle Mike, the trustee, manages them, and he gets to use the money for their benefit, right? He can use the money to help pay for college. Anything medical related that's above and beyond what insurance would cover, he can use it for. And then really anything above that is going to be at his discretion. Now that's just the way we've laid it out. People can be more specific if they want. We tend to keeping it broad because we don't really want to be that restrictive because we don't know what might come up later on where it might be beneficial for that trustee to be able to use the money for. But again, people can be as restrictive as they want. There's nothing wrong with that. So Uncle Mike, the trustee, can use the money for these things that come up, again, at his discretion. I always use the example, our son says, I need a new car. I really like this, Mercedes AMG truck, and it's only $130,000. Uncle Mike says, that sounds great. Let's go look at a used Camry. We'll see what works for you, right? And so again, the idea is I would look at that trustee almost like a surrogate parent from a financial standpoint only, right? You got to think about it like if you were still alive, your kids will be coming to you for money if they needed it, right? But in this example, we're not, and so they're going to the trustee. And so the idea is that we're naming a trustee that hopefully has similar values to us and would treat our kids or our beneficiaries in the same manner that we would treat them if we were still living. When we leave money to beneficiaries, whether it's our kids, our siblings, whoever, we always have to take into account that they may not survive us, right? Where does their share go if they don't survive us? Does it go to their kids if they have kids? We can always put those provisions in even if they don't have kids, right? Because the goal in planning with everybody that we plan for, and this should go for every attorney that does this, is thinking many steps in the future. Not that we want to think about those things, but the idea is we can account for certain things that could happen down the road so that clients don't have to come back to us and continue to make changes to their documents for things that we could have anticipated. Again, we don't want them to happen, but we can at least anticipate that certain things can happen, okay? That's really how a trust works in the most basic sense, okay? Again, I want to just go back to the idea that, to be clear, IRAs, 401ks, life insurance policies, those do not get retitled to a trust. Those we simply use beneficiary designations on them. Now, in a lot of cases, we might have a trust named as the beneficiary of a life insurance policy, okay? That's not uncommon. In some cases where we have minor children, in my case, right, my wife is primary beneficiary of my IRA, but the trust is contingent. And that's because the trust has all this language that says our kids don't get access to the money until they're 30, okay? So I'm not saying the trust should be beneficiary of any of your IRAs or 401ks. It really depends on your particular circumstances, who you're leaving the money to, how old they are, how responsible they are. There's a lot that goes into that. I just want to kind of give you an example that in some cases the trust may or may not be named as the beneficiary of an IRA or 401k. I'll touch on it really briefly. This example I gave you was really the idea of a joint trust, right? My wife and I creating a trust together. So in Illinois, we have an estate tax limit of $4 million, all right? We'll kind of call it like a coupon, right? We all have this a coupon that the state of Illinois gives us, and that means that at the time that I die, I can pass on up to $4 million tax-free. Clients always ask, is there inheritance tax in Illinois? Not really. The people that are inheriting from you, they're not the ones paying tax. But if I have a $5 million estate that I'm leaving to my kids, then there's $1 million that will get taxed because I get a $4 million coupon. So $4 million passes tax-free, $1 million will be taxed, but it'll be taxed before it gets to them, if that makes sense. It doesn't go to them and then they pay a tax. Now, of course, any IRAs or 401ks that your beneficiaries inherit, when they start to cash those out and take distributions, they're going to pay taxes, and that's just how those certain assets work, okay? So let's use the example that, let's say my wife and I had a $6 million estate. We definitely don't. Let's say we did, okay? In that case, we're probably not looking at a joint trust, okay? Because the $4 million coupon in Illinois, it's not portable. Portable meaning, let's say I pass away first. I can't give my $4 million coupon to my wife, meaning she can then pass on $8 million tax-free at her death. Okay, we only get $4 million each, okay? So if we have a $6 million estate, it's probably going to make sense for us to set up two different trusts. A trust for Christina, a trust for Matt, all right? Now the reality is the terms of the trust are typically with married couples identical, right? The beneficiaries are the same, we're probably naming the same backup trustees, everything. Because again, we're only really doing this to protect against estate taxes. So the way it works is, I'm the trust maker of my trust, my wife is the trust maker of her trust, we're actually going to be co-trustees of each trust. Okay, so we're both going to have access to all the assets that are in each trust. Now, the way that we protect against that estate tax issue with a $6 million estate is we try to divide the estate. So let's just say we put $3.5 million in my wife's trust and $2.5 in mine. And I use that example because it's almost never going to be 50-50 in these situations when we work with clients. Maybe somebody's got a large IRA, maybe there's a big brokerage account. So we can do our best, but the idea is to try to split it up to some extent so that neither one of us is over 4. So in this example, my wife has $3.5 million in her trust. I've got $2.5 million. I pass away. So again, both of our trusts operated off our Social Security numbers during our lifetime. At my death, my trust gets a tax ID number or an EIN, if you're familiar with either one. What that means is now my trust is going to file its own tax return every year. My wife will be the trustee. She'll manage it, but she's going to file a tax return. What that means is that those assets in my trust never get added to her estate for tax purposes. So she can have access to the money in my trust. She can use it for her benefit, for the kids, however she wants. Then upon her passing, her $3.5 million in her trust, my $2.5 million in my trust passes to our beneficiaries tax-free. Okay, so that's just the little quick comment I wanted to make on that, and sort of how we do plan in the situation where we do have an estate that's taxable by Illinois standards. Some states don't have estate tax. Florida is the most common one that people are very familiar with. No state estate tax, so you're not subject to that type of planning or having to do that type of planning. You're only subject to the federal estate tax, which for a married couple is close to $25 million. It's a little over $12 million a person right now, and that is portable, meaning the second spouse can actually pass on twice the amount tax-free. But if you fall into that category, you're really not a good fit for us because we don't handle estates that large. So, all right, we've talked about the will, we've talked about the trust. Let's talk about just a few other documents that really make up a very traditional estate plan. So we look at, before I get there, we've got the pour over will. So in every case where we create a trust, we are always going to set up a will. We refer to that will as a pour over will. Okay, really it's a safety net. Because again, I mentioned this earlier, there are situations where somebody creates a trust and their estate still goes through probate. And that's because they might have forgotten to retitle certain accounts of the trust. Maybe they inherited that lake house from their parents 15 years after creating their trust, and they never retitled it to the trust. In some of these cases, I blame the attorney, because I think there's a lot of attorneys out there that do planning for clients, that put trusts together, and they don't give any guidance to the clients about the fact that they actually need to retitle their assets. And so in those cases, it's not the client's fault. But then in some cases, it is, unfortunately, because the attorneys, and I'll tell you that I think we do a great job of telling clients, walking through everything they have and saying, listen, these are all the accounts you have. You have to go to Bank of America and retitle these. You have to go to UBS and update these investment accounts. We're going to take care of retitling your real estate in Illinois. We're going to work with an attorney in Michigan to retitle that lake house to the trust. And then you've got to update the beneficiaries on these IRAs, 401ks, and life insurance policies. Now we know in some cases, unfortunately, clients will let something slip through the cracks. Or again, maybe they'll inherit some account down the road, or they'll open some new account down the road and it's not in trust. So even with a trust, if there's some asset that I have that is in my name only at the time I die, not in the trust, not owned jointly, no beneficiary, it can still go through probate. And if that happens, my pour over will is going to kick in. My pour-over will, when I have a trust, is a super simple will. It'll name executors, and the executors of my will are probably going to match up with the trustees that I name in the trust. And then, really, rather than going through all the beneficiaries in the will, my will is going to say that the beneficiary of my estate for probate purposes is the Matt Margolis Trust. Okay, that's what it means by pour over, right? My will pours over into my trust. And if I've got minor children, I also name guardians in there, okay, to be clear. That's always the document where we name guardians, always named in a will. So to make it very clear, the pour over will is really a safety net, right? It's there in case we need it, to make sure that if something slips through the cracks, it still goes, and it goes through probate, it still goes and passes through our trust, but I hope we never use it, right? I really hope we never use that pour over will, because that means we're still going through probate. And the pour over will doesn't make the probate process any quicker, okay? It just ensures that whatever we have that's going through probate will end up passing through our will, or passing through our trust. Okay, now to these other documents. So we've got a few other documents that really make up any kind of traditional estate plan. So we've got powers of attorney for healthcare and property, a HIPAA, and a living will. So powers of attorney, to me, are some of the most important documents I think that people should have. And I think a lot of people just sort of pass over them, and they don't really think about them a lot. And they're sort of, a lot of people will say, oh, I can just print them online, or my doctor's office gave me one, or I went in for a surgery and the hospital had me sign one at the last minute. I think I'm all set. We put power of attorney documents together in case we get to a point where we cannot make our own decisions, right? This isn't for when I die. When I die, the powers of attorney go away. But while I'm alive, if something happens to me and I'm incapacitated, right? There's an accident, I'm in a coma, I'm temporarily incapacitated, maybe I have dementia and I no longer have capacity, well then I really should have power of attorney documents. And there's one for healthcare and one for property. The healthcare power of attorney is one where I'm naming somebody to make medical decisions for me in the event that I cannot make my own. Okay, I can name as many people as I want, but on this I'm naming them one at a time, in succession. Okay, Illinois does not allow me to name two people together like I can for executors of a will or trustees of a trust. They're being named one at a time. All right, again, I have to be selfish. Who's going to be the best person to make medical decisions for me? And who's going to be comfortable making my decision for me? And what I mean by that is, for example, I don't want my life artificially prolonged, right? If something bad happens and things don't look good, I don't want to be kept alive and just hooked up to machines and just be strung along, right? I don't want to be the proverbial vegetable. I hate to use that term, but I think it's the one that some of us we've heard, where it's common, right? That's not how I want to live. And so I need to make sure that when I'm naming people on my healthcare power of attorney, I'm also talking to them first and saying, listen, this is how I feel. I want to make sure that not only are you comfortable making sort of all those day-to-day medical decisions, which just might be, think about when you go to the doctor, certain things you need to decide. Do you want to take this prescription? Do you want to have this surgery, etc.? But are you comfortable making these end-of-life decisions for me, the decisions that I want? And I've had clients over the years, plenty of times, come back and say, the person I thought I was going to name, I'm not, because they're not willing or they're not comfortable making the decision I want them to make. Better to know ahead of time, right? So again, healthcare power of attorney, we're naming people to make medical decisions for us when we cannot make our own. The property power of attorney. So the property power of attorney is not just property in the sense of real estate, it's really who can step in and make all those decisions for me that are not healthcare in nature. And if I have a trust in place, that are not anything regarding assets that are not in trust. Because if I have a trust and I'm incapacitated, that successor trustee of my trust will step in and deal with my house, my bank accounts, my investment accounts, if they're all in the trust. Now, in a lot of cases, my power of attorney for property, and I'm naming them one at a time, right? I cannot name them together, one at a time in succession. But in a lot of cases, the people I name as my power of attorney for property are going to match up with the people I'm naming as trustees of my trust and executors of my will. Sometimes the black sheep can be the healthcare power of attorney, because it's two different skill sets, right? One is really dealing with financial matters and really just everyday, like I say, running a household matters, versus healthcare, which to me is different. And so the property power of attorney would be things like dealing with Social Security if issues arise, Medicare, signing a contract on my behalf, filing my tax returns, dealing with my IRA or 401ks or life insurance policies. Again, regardless as to whether I have a trust, those will still be owned by me. I'm just going to be dealing with them with beneficiaries. When it comes to naming a power of attorney for property, I think a lot of clients go to this place of like, oh, my daughter's an attorney or my son's a CPA, they would be the best person to name. And my response typically is, you're a school teacher or you were a school teacher. Somehow you've been able to manage your life and handle all these things. Why do you feel like the person that you're naming to be your power of attorney has to fit into one of those categories? It actually might be your son or your daughter who's a stay-at-home parent, because they're the ones really running the household. And when things happen, they're the first ones that are going to be able to take care of it, versus your kids or your brothers or sisters or whoever that are working 60 hours a week, that have a hard enough time, dealing with all the things outside of their work, outside of work, that taking on another responsibility or taking on things that relate to you might be more difficult for them. So again, just different things to consider. If we don't have powers of attorney in place and we become incapacitated and we are over the age of 18, the only way to get somebody to make decisions for us is to go through a guardianship. And then somebody close to us is hiring a lawyer, going through the guardianship process, which is in court, and now you're talking about a situation that's going to take time and cost money. And now, when certain decisions need to be made over time, that guardian is going to have to hire the lawyer, go into court, and actually get court permission for certain things. Okay? Not ideal. Not ideal. And one thing just to throw in there is, for all of you that might have younger children going off to college, I think one thing that's really not thought of much is that when we turn 18, we're the only person in the world now that can make decisions for ourselves. We're not, when my kids turn 18, I don't get to have access to their medical records without their permission. If something happens to them and they're at college and I need to get information from the school, I'm not able to access that. I'm not able to just go into their bank accounts anymore if they've got bank accounts in their name only. And so, one thing to really consider is the idea of even looking at powers of attorney for 18-year-olds. While we've done them in the past, we've actually done a lot this last year, a lot more than ever. And so I'm not sure what the push has been. It really hasn't come from us, to be honest with you, but it is really important to be considering powers of attorney for those 18-year-olds or 19 or 20 or whatever, that are, again, for those kids that are off in college. Because again, we all know things can happen. We obviously hope they don't, but God forbid they do. If we've got power of attorney and we're able to then step in for our kids in a difficult situation, one less thing to worry about. So talked about powers of attorney. Now we've got the HIPAA. The HIPAA is the healthcare authorization, right? Who can have access to my medical information? This isn't who can make decisions for me, to be very clear. That is the healthcare power of attorney. The HIPAA is who can have access to my medical information, right? And to me, there's really two main things somebody that's on my HIPAA can do. Who can go to my doctor and ask for copies of my medical records. Okay, I'd say most of the people that are on my HIPAA probably would never do that, but I have to be comfortable that they could. The other reason, or the other thing that somebody can do with a HIPAA, which I really like, is if there's an emergency and I'm rushed to the hospital, okay, and I can't communicate, obviously, anybody that's on my HIPAA can call the hospital, find out what's going on. They can show up, they can talk to the nurses, to the doctors, to the staff, and they can be told what's going on with me. On the HIPAA, I can name as many people as I want, and there is no particular order. So it doesn't matter if I put my wife's name up here as first or last. And again, there's a lot of situations where I might have more people named on my HIPAA than I have on my healthcare power of attorney. Right? My healthcare power of attorney has my wife, my mom, my brother, in that order. But on my HIPAA, I've got the three of them plus some of my other siblings, my in-laws, etc. So, there's certain people that I'm very comfortable making medical decisions for me, but there's a number of other people that I would want to be able to have access to information if something did happen to me, okay? And the last document is the living will. The living will is the do not keep me alive unnecessarily document. This is not the same as a DNR or what's now called a POLST, P-O-L-S-T, Practitioner's Order for Life-Sustaining Treatment. That document, the DNR, POLST, same thing. That document is something that you would sign with a doctor or with another medical professional, and it needs to actually be signed by a certain medical professional to be valid. And that is going to explicitly say, I do want to be resuscitated, or I don't want to be resuscitated. It talks about, do you want to be kept comfortable in a end of life scenario, or do you want to, be kept alive no matter what? And then how do you feel about a feeding tube or any kind of artificial feeding? That's a POLST or a DNR. That's not something we do in our office. That's not really something most estate planning attorneys do in their office. If you're interested in that, you go to your doctor and discuss that with them and see if it's appropriate for you. The living will is going to be really that document for clients of ours or for those people in general that again, sort of value the quality of their life over the quantity. And so while most attorneys will sort of include it in their estate planning package, similar to us, there's people that don't want to sign it, right? Because they want their life prolonged to the greatest extent possible. And it might be just because how they feel. Sometimes it's for religious reasons as to why they do that. And everybody's entitled to their own opinion, obviously, and whatever's right for them. And so the living will may not be signed by plenty of people. There's going to be certain people that will sign it. And again, really, I look at that living will as just more evidence to your healthcare power of attorney that you do not want your life artificially prolonged, that you want to be kept comfortable. It doesn't mean don't try. It just means don't use extreme or potentially maybe what we consider unnecessary measures or extreme measures in a situation where I'm very likely to have no quality of life. Okay, and I'm only going to be kept alive with machines or very extreme measures. So, really these are all the documents that we tend to look at as really a more traditional estate plan. Whether it's a will or trust that's sort of at the head, and then you kind of go down and you add the powers of attorney for property and healthcare, the HIPAA, the living will. And so that's really what we're talking about as far as what makes up a pretty traditional estate plan.